Hi, this is Michael Hart, and this is presentation for Constitution Day 2025. I would like to address the case called City of Grants Pass versus Johnson, decided at the end of last Supreme Court's term on June 28, 2024. The facts of the case are as follows. City of Grants Pass, which is located in Oregon and is very much its own small city, close to the border of California, which is a fact that becomes important shortly, created a number of ordinances that imposed escalating penalties, fines eventually up to brief incarceration up to 30 days for sleeping in public parks. And if you slept in public parks or other public property using any bedding or shelter materials like blankets, pillows, cardboard, you could eventually be incarcerated, but it would start with a fine of $295, and then it would escalate from there. And if the fines were unpaid, after multiple citations, you could be excluded from city parks, and further violations could lead to criminal trespass charges, punishable, like I said, by up to 30 days in jail. So homeless population in Grants Pass at the time was 600 people, which is a lot, which is about 1.6% of the population. And like I said, it's its own city. It's nowhere near Portland, Oregon. So it's not like a suburb that experiences a lot of homelessness within a much larger metropolitan area, like, let's say, Santa Monica would be within Los Angeles County. It's not like that. So we see here an interesting social or sociological phenomenon, and that homelessness has become a very serious issue, not just in larger cities, but also in small towns. So the lawsuit in 2018 began in 2018 as a class action by Gloria Johnson and John Logan on behalf of the involuntarily homeless class. And to say that you were involuntarily homeless was to say that you could know where to go, including shelters, because shelters did not have enough qualified beds. And in an earlier case called Martin versus Boise, the Ninth Circuit Court of Appeals defined available beds as those that not just physically existed, but also did not violate any provisions of the Constitution. So, for example, if you had a shelter with available beds, like you did at Grants Pass, but the shelter itself required you to attend religious services, as the Grants Pass shelter did require, then such beds could not be counted as those as adequately available, and you would be classified as part of the class of the involuntary homeless. So, what was actually the question in this particular case? Did the Eighth Amendment Cruel and Unusual Punishment Clause prohibit local governments from penalizing homeless individuals for sleeping outdoors on public property when no alternative shelter is available? So, in other words, can a city enforce generally applicable anti-camping ordinances against people with no choice but to sleep outside, or would such enforcement amount to an unconstitutional punishment of homeless status? So the majority opinion was authored by Justice Gorsuch. The decision was 6-3. It was strictly along ideological lines, and Justice Gorsuch wrote that the Eighth Amendment traditionally applied to punishments and not toward questions of criminalizing certain acts versus other acts. So when you deal with the Eighth Amendment, says Justice Gorsuch, the correct understanding is to ask what is forbidden after criminal conviction, subsequent to criminal conviction, not which conduct can be criminalized. Okay, so all right, so that's the first thing that the majority wanted to make clear. Second, the majority said that we have to differentiate between status and conduct. And to understand this, we have to turn to a pair of cases, both decided by the Supreme Court in the 1960s, Robinson versus California and Powell versus Texas. So in Robinson versus California, the Supreme Court said you could not criminalize a condition, a status, like an addiction. So you could not criminalize, for example, being addicted to illicit drugs. That's a no-no. That's a violation of cruel and unusual provision of the Eighth Amendment. However, in Powell versus Texas, the Supreme Court said that you could criminalize conduct that results from addiction. Public drunkenness can certainly be criminalized, said the court in Powell, even though being addicted to alcohol cannot be. So, a very clear differentiation is established. And the court also said, look, even without these first two things that we just addressed, if you look at the penalties in this case, they do not go any higher than 30 days in jail and $1,250 in fines. So if you look at that, what is it that we're dealing here with at the highest level of abstraction? We are dealing with minor crimes, sleeping in public against the city ordinance, and minor penalties imposed for these crimes. And this is in line, the punishment here, okay, this brief incarceration and a modest fine is in line with kind of punishment that you would get for minor offenses other than sleeping, in public spaces in violation of the ordinance. It's very much in line with what other minor offenses are being punished. And of course, the Supreme Court rejected the Martin injunction. It overruled the Ninth Circuit Court's so-called Martin experiment in Martin versus Boise, and said, we overrule this, and that you can in fact have an ordinance against sleeping in public spaces, because it's just neutral. It's a neutral ordinance. It applies equally to all. Doesn't punish the status of homeless, a tourist who may not have enough money to pay for a motel, may end up sleeping on the street. So it's an ordinance of general applicability. Policy and federalism consideration were also something that the court mentioned here, saying that homelessness is a serious problem and it is best addressed by local governments. It should not be addressed as a one-fits-all solution by the Supreme Court. So there was an interesting concurrent opinion written in this case by Justice Thomas, who criticized the so-called evolving standards that the Eighth Amendment jurisprudence developed since the 1960s. So while Justice Thomas agreed with the decision, he wrote this concurrent opinion to reject even the holding in Robinson versus California, which established that conduct status distinction. Because according to Justice Thomas, the Eighth Amendment should not deal with these matters at all. They should be passed over in silence. The Eighth Amendment should only deal with the types of punishment, and nothing else should be considered at all. Also, according to Justice Thomas, the ordinances here implicated civil fines almost entirely, while criminal penalty of 30 days in jail was a possibility. This possibility was, according to Justice Thomas, very remote. And yes, I agree. Because the criminal part of the ordinances would not even be invoked except as the last resort and only against the most recidivistic of violators. This really was a civil case. And the Eighth Amendment should not be operable here. Okay? And of course, we had a passionate dissenting opinion by Justice Sotomayor, in which Justices Kagan and Jackson joined. So according to Justice Sotomayor, the majority made a mistake when it separated between status and conduct in this case. So while it may not be a stretch to make such a separation in other cases, it is an illusion to try to separate conduct and status in this case, because being homeless and sleeping are inseparable. So sleeping is a biological function, and as such, you have to engage in it. So according to Justice Sotomayor, you can only separate between conduct and status when there's a plausible choice that you can make. But here, there is no possible choice. If you're homeless, you have no choice but to sleep in public. And to penalize people for doing so is to target the most vulnerable people. So, and she says the Supreme Court was wrong to overturn the Martin precedent imposed by the Ninth Circuit Court of Appeals, because you can still punish an egregious conduct that's involved in homelessness. So while, according to Justice Sotomayor, it would be a violation of the Eighth Amendment to punish sleeping in public if you're homeless, it's not egregious and it's not unconstitutional to punish behaviors like going to the bathroom in public urination, for example, or using drugs, or dealing drugs in public spaces. It's an interesting argument. It may be a little bit too optimistic, because she refuses to grant to the majority the idea that you can separate between status and conduct. She says if your status is that of being homeless, you will end up sleeping in public spaces. And yet she says just because you are sleeping in public spaces, you can separate between that and going to the bathroom in public, or dealing drugs or using drugs in public. So but nevertheless, that was her opinion. And like I said, the two other liberal justices joined in this opinion. Unfortunately, homelessness remains, if I may add a bit of a sociological commentary here, an intractable problem. According to the Department of Housing and Urban Development, in January of 2024, on any given day, there were 771,480 homeless people. So this is like a point in time estimate, approximately 771,000 on any given day. And if you were to consider for the whole year, the number would be greater than that. There's no exact estimate, but the overall numbers are always greater than point-in-time estimates. And even I would say that point-in-time estimates are probably underestimate the number of homeless people in the United States. So what we do know about this issue is that two factors are significant in explaining homelessness, very significant, and that's substance use disorder and mental illness. But there are other factors, for example, lack of affordable housing. Now, the majority mentions figures of around 75% for substance use disorder and approximately the same number for mental illness. And of course, they would end up to much greater than 100% because there's a significant overlap. Many of the people who have substance use disorder and are homeless are also the people who have mental illness. So I have seen estimates that significantly lower than 75% for the combined total of these two factors in terms of explaining homelessness. So I have seen estimates who give greater weight to economic factors like chronic job loss, chronic unemployment, and lack of affordable housing. But whatever the case, it's very clear that the mental illness epidemic and the substance use disorder haven't been significantly addressed, and these two are certainly the root causes, or among the root causes of this terrible problem that afflicts the United States of America, and in fact many societies around the world. So this is my presentation. Thank you very much.